a fundamental course on legal studies. First chapter. The qualities of efficacious or successful systems of justice. In this course, the qualities of efficacious or successful systems of justice shall be briefly expounded. Establishments and processes for solving problems of disagreements shall also be briefly expounded. The following are the successful systems of justice, or the following are the qualities of an efficacious or successful systems of justice. Fairness, impartial and incorrupt hearings, and justice for all. 2. Ability to reach establishments and processes for solving problems of disagreements. 3. Employing time actively and shrewdly in solving problems of disagreements. 4. Human rights and all other rights of the people acknowledged. The qualities above are the qualities of a system of justice that is working correctly and satisfactorily. In essence, a system of justice that is working well and satisfactorily is one that achieves good results. The correct upshot: a right ruling made in court, a jury verdict that is correct, without error, made without some bias or prejudice, or a court's right use of sentencing rules. The definition here is somewhat vast, implying that the idea of a system of justice that is working correctly and satisfactorily may be interpreted in quite a few ways. Accuracy in a clear expression of the meaning of things working correctly and satisfactorily is certainly not easy, as perspectives are not all the same. Perspectives change and depend highly on the observer. In other words, perspectives of efficacy, things working correctly and satisfactorily, will be different. The degree to which certain individuals are affected is an important factor to be considered. Observing daily instances of crime, the system of justice is challenged and must resolve tough problems, defending freedom, human and civil rights, and liberties of the people and of each person in our society, and must preserve and enhance all establishments and processes for detecting and stopping crime, for the correction of offenders, and for the safety of the public, and national and international security. In any society, plaintiffs and defendants, victims and offenders never have the same views on crime, but always see things differently. One may observe the verdict of a jury as efficacious, working correctly and satisfactorily, while the other may observe the verdict of the same jury as inefficacious, not working correctly and satisfactorily. Also, the system of justice and convicted offenders may hold diverse opinions regarding efficacy of the processes employed in dealing with criminal offenses and disputes. But it should not be forgotten that the opinions and views of the people regarding the efficacy of the system of justice is almost always weightier than one person's opinions or views. The voice of the masses, what the people say, is extremely important in a democratic system of justice. There are two kinds of efficacious justice. The first is procedural justice, and the other is substantive justice. Procedural justice simply means the judicial processes for arriving at an upshot, result, or verdict. Substantive justice, however, means the real result, the real upshot or verdict in the system of justice. And thus, an upshot or verdict may be described as procedurally just if the processes for arriving at the ultimate result or judgment were fair or right, without bias or prejudice. Also, an upshot or verdict may be described as substantively unjust if the ultimate result or judgment was incorrect or not right, considering all things, all points, all facts, all proofs or evidence. Fairness. Fairness simply means that processes or upshots in the justice system are without bias or prejudice to both plaintiff and defendant, etc. When there is fairness in a justice system, decisions and verdicts are reached peacefully, and there is harmony and progress in society. When is there fairness in accordance with the law? There is fairness in accordance with the law when the rights of the people are defended, upheld, and guaranteed always. In a pretrial process, an individual has the following rights: the right to be silent and remain silent, the right to have an attorney or defense counsel, the right to seek bail and petition for bail, etc. In a trial process, an individual has the following rights: the right to have an attorney or defense counsel, the right to be tried by a jury where the charge or accusation is indictable, the right to be assumed innocent until found guilty, the right to be tried by a free and impartial judiciary, jury, magistracy, etc. In a post-trial process, an individual has the following rights: the right to appeal if dissatisfied with a decision or verdict, the right to be pardoned if there is a good reason for this, the right to a proper, incorrupt correctional process, ability to reach appropriate establishments and processes. There are many establishments and processes employed today in the proper and correct settlement of disagreements and conflict, in accordance with the established statutes and systems of justice. This section deals with the ability to reach appropriate establishments and processes, which are ultimately the framework for the settlement of disagreements and conflicts in the system of justice. The establishments and processes accomplishing this task may be grouped as formal, non-formal, etc., depending on the precise way of working the structure, etc. There are many establishments and processes for settling complaints, disagreements, and conflicts. There are a good number of complaints and disagreements which are successfully settled without employing the main court system. It is impossible to live in a world without disagreements. There must always be disagreements between human beings. One good way in which systems of justice help accomplish right results is by developing processes and creating establishments to respond to complaints and settle disagreements. Establishments and processes for proper and efficacious settlement of complaints and disagreements are required by the systems of justice. New standards in the modern world require that complaints and disputes be properly settled in accordance with the law. Establishments and processes for the settlement of complaints and disagreements are required by law to eradicate disorderly, ill-bred, and criminal tendencies from our communities and states. In the modern world, there are many developed towns and cities with large numbers of people. Obviously, there are many opinions and beliefs held by these masses of people. The difference between the people and their views and practices many a time conflict and need proper settlement for there to be harmony, peace, and progress in the community. Without a just and satisfactory settlement, outright lawlessness and disorderliness could result. And if this happens, the rights of the people, their lives and properties will be greatly endangered. For instance, Ferguson, Missouri was hit by looting and arson in November 2014 following a grand jury decision on the Michael Brown case. In a large democratic society and system of justice, the people or masses have many different views and many different beliefs, many different opinions, and many different cultural and other practices. And in their daily interactions and businesses, the people have many disagreements and conflicts needing settlement. The system of justice builds many establishments and develops many processes to settle the various disagreements and conflicts that occur between the people. The main establishments employed for the settlement of disagreements and conflicts are the courts, Supreme Court, Federal Court, High Court of Justice, Appeals Court, etc. But today, in the systems of justice, other kinds of establishments and processes for the settlement of disagreements and conflicts have thrived. And so, there are quite a few alternative establishments for the settlement of disagreements and conflicts which advance beyond the main courthouses. The settlement of disagreements and conflicts. The state and the local communities require that disagreements and conflicts be resolved satisfactorily in a right and peaceful way. When disputes are not settled, when disagreements rage and are not controlled, the proper ruling and progress of the system of justice, of communities, and of the state is jeopardized. The judiciary and law enforcement agencies have a duty, an important task to accomplish here in maintaining law and order, in defending the rights of the people, and in protecting the community from ruin and anarchy.